Hello and welcome to this press conference being brought to you by the Government Information Service. I am Jordan Bisset Joseph. As part of the 50th anniversary of the Eastern Caribbean Supreme Court, the Registry of the Supreme Court have embarked on a campaign to raise awareness and also to sensitize the public in regards to awareness on the use of mediation as an alternate to dispute resolution. The panel is made up of Dr. Urban Seraphin, Justice Francis Bell, and Mr. Francis Compton. I'm now about to hand you over to our panel to find out more. Gentlemen, good morning.
Good morning, moderator.
Good morning.
Thank you to the Government Information Service and to the members of the media who are here this morning for this inauguration of the campaign for the mediation and commemoration of the 50th anniversary of the Eastern Caribbean Supreme Court. Now, that celebration, the actual date was the 27th of February, and the date of the inauguration was the 27th of February 1967. So that it is that period of 50 years from since 1967 to now that we are celebrating. And the thought that went behind this celebration and this campaign for mediation is that out of many things that have developed in that 50 years, it is difficult to find anything that is as significant as the civil procedure rules of 2000 and the step taken in those rules, the inclusion of mediation as a method of resolving disputes through the court. Because prior to that, the only way to resolve your dispute through the court was to basically go before a judge. Of course, people always had the opportunity to meet privately and negotiate settlements, and that always happened. But now it is a formal part of the court's procedures. The rules provide for it, and there is a practice direction based on the rules that also provides and fleshes out how mediation is supposed to work. So the Court-Connected Mediation Committee, which is established by the practice direction and is made up of members of the community, including lawyers, trade unionists, religious people, persons from the Chamber of Commerce, public servants, and others, and the Registry of the High Court have got together to put on this campaign to sensitize, as the moderator said, to educate people about mediation. Because in spite of the fact that we may feel that we've been going since 2002 or 2003, and one of the other panelists who actually were here at the time could give us a better idea of when they actually got started in St. Lucia. In spite of that fact, there's always need to remind people of the availability of mediation and the usefulness of mediation. So I just wanted to start by saying that, and maybe one of my fellow panelists could start the ball rolling also by defining mediation, and then probably we could take some questions after that. So, which one of you?
Okay. Mediation really is a program, as Justice Bell mentioned, which is introduced by the court. The court for a long time had been plagued with a great backlog of cases to be dealt with, as well as a delay in settling cases. And the court, during its reform process, decided that it would use mediation as the preferred means of assisting the court in resolving disputes in an amicable fashion. Now, a simple definition for mediation, which should put us right, is that mediation is an informal process that employs a neutral and impartial person to facilitate discussions between disputing parties in an effort to bring them to a mutually acceptable resolution of their dispute. Now, that neutral third party is the one we refer to as the mediator. Now, unlike a court process, which is a public process, if you go to court, all members of the public are invited to listen to and to see what happens at the court. In mediation, however, it is all done in private, and it is all informal. There are no trappings of the court, although very often mediation is done within or close to the court, but it is completely separate and distinct. And usually the neutral third parties are laypersons. They are not necessarily trained lawyers or they are not judges. They are persons who have been selected and appropriately trained, persons from the community who have already developed not only an interest but a reputation in the community from which they came, people who already looked up to. And those persons are equipped with the skills of a mediator in order to mediate at the level of the Supreme Court. Now, that process started in 2002 when, under the then Chief Justice Sir Dennis Byron, who is now the president of the CCJ, he started this court reform program, and he had someone, a lady called Mrs. Deborah Mendes Bowen, who developed the mediation program for us, and she also conducted the first set of training workshops in order to train persons to be mediators. At that time, she also assisted the court to identify cases which could readily be resolved by way of mediation, because remember, the mediators were freshly trained, they had no experience. So cases, appropriate cases were selected to begin with, and the rest for us is history. So persons were able, because of the level of training, were able to move from the training workshops straight into a room in order to mediate disputes which were already in the court.
Yes.
I can say a lot more, but please.
Yes, I can remember that in 2002, when Sir Dennis Byron established the court mediation, and of course you and I did some training together, and I was certainly very animated for the establishment of the mediation, because I always argued that it is better to mediate than to litigate, because litigation is always actually, and I don't mean to be unkind to our attorney friends, is making of monies, and people were a little despondent. So it was very good that the mediation project came on board. But certainly what I liked about the establishment of mediation, as Mr. Compton echoed, was that minor cases such as landlord-tenant issues, commercial contracts, employment dispute, land dispute, debt collection issues were many of the issues that were coming up and were going to the court that was taking an enormous amount of time. And of course, mediation helped to alleviate the length of time it would have taken to resolve issues. So as a mediator from 2002, I think it's a wonderful thing for our country, it's a wonderful thing for the people, it's a wonderful thing for our respective communities to help resolve issues that might otherwise take a year, 2 years, that could be done. And above all, and I know this is going to come up, above all, it is much cheaper than actually securing the services of an attorney. I would wish to stop there this time.
Yes, and if I could add, if you put those together, then what you have is a process that reduces the time spent in relation to, when you compare it to litigation. It is cheaper, and it is more likely to produce an agreement between the parties, or to produce a resolution that both parties agree with and own. And I think that is very much better for the community. It is also important to note that a matter is referred to mediation when it meets certain criteria. So the judge or master of the court or the lawyers in some instances can look and assess any particular dispute. And of all the categories that were just identified, any of those, and consider whether the relationship between the parties is important. What is the relationship? Is it a personal, a family relationship? Is it that they are neighbors? However you look at it, there's possibly, based on a relationship that is in existence, a reason why you want to maintain that relationship. So you don't want sometimes the harshness that can come out in a court case situation where people are trying to just win. You don't want that necessarily in all circumstances to be the way in which you go about trying to resolve your dispute. You also look at the willingness of the parties to resolve the matter by way of any form of collaboration. So if the parties themselves are expressing some willingness, and sometimes the lawyers would know this, sometimes when the matter comes to the court at case management, you can see or hear from the parties and the way in which they speak to one another and the way in which they speak about the case that they are willing to collaborate in a resolution. You can see that there may not be a great deal of distance between one person's position and the other person's position. And you can also look at the question of joint gains for the parties in terms of resolution. And I reflecting on that, I can think certainly, although the family law matters were not included in the practice direction, many matters in the family relationship situation and divorce are now being mediated. And one could certainly see the whole idea of joint gains there. In a family situation where there are children, you cannot just split up and move on. You have to look at the benefits to the family of resolving issues in relation to the children, in relation to the maintenance of them, and so on and so forth, and sometimes the maintenance of parties. And I could go on, but the whole point I'm trying to make is that the mediation is not just something that the court is doing to help the court. This is also having seen the story, so to speak, coming out of what is filed in court proceedings. A judge or master and the lawyers can see where there's an opportunity for mediation and have the matter referred to mediation. And in doing so, they would assist then those people who are members of the community to resolve their relationship issues, as I said, whether it be personal, neighborly, or business relationship. If there are persons who are interested in collaborating, to help them to collaborate and to achieve joint gains. So however you look at it, we can see how mediation benefits not just the court, but the community. And I think it is very important that that message be sent out. What we are saying as the theme for our campaign is let us mediate to resolve our disputes. And that does not just mean court disputes or court cases. That means any dispute that there may be in the community that we think, from a policy point of view, ought to be resolved peacefully.
Yeah, one of the things I think it's necessary for us to indicate this morning in commemoration of the 50th anniversary of the Eastern Caribbean Supreme Court. The mediation program was started in St. Lucia basically as a pilot program to see whether it would work and to what extent it would benefit the members of the public, disputing public in St. Lucia. But not long after the program started, I know for sure that some of the judges who were in the Supreme Court at the time in St. Lucia would pass around sometimes near the mediation room. And of course, they would discern a completely different atmosphere to what happened in the courts. Because as one judge at the time reported in writing, he said he was amazed to hear peals of laughter coming out of the mediation room to express how not only cordial but how informal the process was. Because in mediation, there are no witnesses allowed. It's only the parties to the dispute. So that project was soon replicated in the remaining 8 states and territories in our OECS region. So every island and state in the OECS have gotten the very same mediation program. The very same training that was given in St. Lucia is the very same training program done in all the territories. So it is very easy for a mediator from St. Vincent to go in one day to the BVI and conduct a mediation there without knowing anything. He can go there, conduct a mediation, and return to St. Vincent with ease. There's no need for unnecessary preparation because it's the very same program, just different faces. And I think it's necessary for me to make that indication, because unlike many other places within CARICOM, in the OECS we have one Chief Justice, we have one jurisdiction, the OECS jurisdiction, but that Chief Justice is responsible for 9 states and territories. It only happens that the head office is in St. Lucia.
Yes. May I, for you, Justice Bell? The 50th year anniversary of this wonderful court within our jurisdiction, but what we have achieved over these years is fantastic for small states. But I just want to let our folks know that because of the work that is going to be undertaken in terms of the campaign for the next few weeks, certainly for this month, I would want to share some of the community things that we are going to do. For example, in Barbono, in St. Lucia, we're going to have a human resource. We're going to go to the human resource to talk about the issues of mediation, how important it is important to overcome the backlog in our court, how it is important for the community as a whole. Then in May, the 16th, 17th, we're going to go to sensitize the police services, the police officers, to get them to be au fait with what the court is doing and to get people to mediate as opposed to referring them to the courts and what have you. Then, of course, in between 17th and the 31st of May, we are going to be in Central Castries to get the members of the public to come and hear why it is so important to mediate. And then we're going down north, is it? Towards Dennery, is it? It's south. Dennery, we're going to start talking to the schools because we believe that there are lots of difficulties and problems that our young people encounter in the classroom with their teachers and their overall community. And we're saying in order to avoid the conflict, why don't our young people start learning how to mediate issues as opposed to developing full-blown conflicts? So we're going to do that in our schools in Dennery, our secondary school, talking to the Form 3s, 4s, and 5s, and to get with their teachers, of course. And then we're going to Ancillary on the 18th and the 17th, again to talk within the community, the parish halls of this community, to educate the people that it is better to mediate than to litigate. because litigation is a costly affair, whereas, as Justice Bell and my colleague, Mr. Compton, suggested, it is a fora where persons do not, although they may have different court, it is a combatant situation. The lawyers who's got the best precedent, who best evidence to convince the judge that is the direction that one goes. Whereas in mediation, it's a question of the individuals discussing their issues to come to a given conclusion, so both parties win. So we're going to do that in the community of ancillary. Then we are going back towards Moshi, where we're going to speak again in the community to discuss the importance of mediation and what have you. And then we're going back to Castries in Masha from the 17th to the 24th, where we're going to talk about mediation, how important it is that we overcome our dispute without cutlasses and guns and what have you, and sitting around the table and to come to some given conclusion. So these are the different places that we are going to go into to discuss the importance of mediation.
Yes. Yes, I would also like to add that the plan also maybe on the 16th to go to Canaries, where we will do a similar exercise as we would have done in ancillary. So the idea is to cover as much of St. Lucia as is possible within that time frame. But we want to also assure you that it is not our intention to use the month of May only to express all our thoughts, wishes and aspirations concerning mediation, but the plan and the idea is for us to keep doing this for the foreseeable future. Now, the reason for this is that sometimes we get surprised when we recognize that after 16 years of conducting mediation in the country and doing it nearly every day, there are several persons who have never heard. I was absolutely appalled some time ago. I was at a meeting and someone who indicated the level of education and they had not heard of mediation. I was taken aback, to say the least. But we discover all the time that there are persons who are going about their business every day and they have not heard about this wonderful process called mediation to use a dispute. Now, it's very interesting that Dr. Serafin suggested that when we go to Babonneau or one of the other areas like this, we want to there's a better way to resolve disputes than using the cutlass. I have to give you the assurance that resolving disputes, there are several methods of resolving dispute, but any method of resolving a dispute that you elect to use, that method would have consequences, and sometimes serious consequences. It is perfect for you to decide on your own to use a gun or a cutlass to resolve your dispute. However, in most cases, the full force of the law will descend upon you. If you go to the courts to resolve your dispute, you don't know at that time you go whether you will win or lose, because the court gives you the opportunity to win or lose. And if you lose, you will have consequences, including a long jail term to face. However, if you go to mediation, you take charge of your dispute and you discuss in a neutral way, in an informal way, your dispute with the person with whom you have the dispute, and you arrive at your own best decision which satisfies your interests and your concerns. Not necessarily your wants and desires, but your interests and concerns. And that way, you can shake hand and arrive at the resolution which best suits those interests. And what we have discovered about mediation is when persons come to their own best decision at mediation, there is a greater tendency to perform or to do what you have agreed to do, rather than if you have a judge impose a decision on you.
Okay. I guess
So the idea is to mediate at all times instead of litigating.
Right. I guess before we go to questions, just the full picture then is that we have tried to involve all of what people call the stakeholders, which are, of course, members of the community. We're talking about members of the church, we're talking about police, we're talking about the lawyers, and of course the mediators. And the mediators have done a great job of volunteering to divide themselves. We think there are hundreds of them in St. Lucia, and some of them have decided to volunteer their time to go to these various places that Dr. Serafin spoke about. So we have the inclusion of all of those mediators who want to be part of that process. They are participating by going to the schools, going to the community groups, speaking to the police, and so on. We also have an opportunity to go to the media in other fora, where we will be speaking on different programs to the media with various other media houses. So we're going to be doing that. Also, we're going to have programs that are specifically geared towards lawyers. For example, a program on the 19th where we are going to have a speaker from the United States who will be speaking about mediation advocacy, which really deals with the whole question of how the lawyer should behave in a mediation session. In our rules, the lawyer is supposed to be present, but they have a particular role to play. It is not like how they operate in the courtroom. And also on the 12th of May, there's going to be a arbitration training, which is another alternative dispute resolution method used in the courts in association with the court system. And that is going to be on the 12th of May. So we have a full program that is touching all areas of dispute resolution that are used in relation with the court's business, and also touching as many of the stakeholders and community groups aligned to it as we can possibly reach. And I think that that is very important. So we could probably take questions at this time.
Okay, well, thank you very much, gentlemen. As we're going to open up the floor to questions now, just indicate if you have a question so we can get the microphone to you.
Good morning, gentlemen. Jason Darius from Choice News. You kept on saying that the mediation method is a cheaper alternative to litigation. In terms of actual figures, what are we seeing in terms of one case?
Yes.
Go ahead.
Yeah. It is intended that any mediation that is done between disputing parties should take about 3 hours. And we have found from practice that very often mediation sessions can last less than 3 hours. However, that does not mean that a mediation session cannot go beyond 3 hours. Very often that can happen. So the court, as Justice Bell mentioned earlier, that the court has equipped itself with a number of persons from the community, various interest groups, to form what is called a mediation committee. And that committee in St. Lucia is headed by Justice Bell as the chairman. What the court has also decided in all the other states and territories, the mediation committee is always headed by one of the presiding judges. Now the committee, because of its composition, can sit and determine, and I'm answering your question a long way to get you to understand what is involved in this. So that committee has the pulse of the community and has a good idea as to how much the community can support when it comes to the cost of litigation. And in St. Lucia, we have arrived at a figure of $400 for the session of 3 hours. So each party to the dispute will pay to the court $400 on the day of the mediation or a couple days before. And that would be the cost incurred if you complete your session in 3 hours or 4 hours. Some mediators, the idea is during the training, we suggest very strongly to the trainees, notwithstanding that the session should go on for 3 hours, it's the mediator's call if you feel that the parties are likely to arrive at a resolution. You don't stop, bang, at the end of 3 hours. You carry on, but the price is 3 hours. Although there is provision for paying an additional sum for every additional hours, because after a mediation session is complete, there may be need to return for another session, either to complete certain things which should have been done and was not done, or to get new information. And we have a questionnaire that we ask persons to fill out at the end of the mediation session. And one of the questions asked is, are you satisfied with the fees charged for the mediation session? That's one of the questions we often ask. And invariably, now it's strange that you should ask that question, because I have a copy of a report which I just received a couple of days ago. And that report suggests that after an analysis of those questionnaires, those appraisal forms, has indicated to us that the majority of persons, over 90%, say that they have not found that the fees are too high for mediation. Now we have, I should tell you, we have similar fees in all the territories. Again, we have those mediation committees, and they arrive. So the fees in the various territories, other territories and states, they're fairly similar. Some may be more or less. The only one that has a big departure from that is the BVI, and I should tell you this is for obvious reasons, because in the BVI they use almost exclusively US dollars, and there is an awful lot of commercial activities going on in the BVI, so their fees for mediation is on a sliding scale and much higher than what we charge here, and it's in US dollars. However, a mediator from Grenada can go to the BVI, as we have had happen before, can go to the BVI and conduct a mediation session there. But if that mediator goes to the BVI, that mediator would be paid the BVI fees and not the Grenada fees. Okay.
Questions from the floor?
Can all disputes lead to mediation?
Well, I think the simple answer is yes.
Yes.
You have the possibility that for policy reasons, there are some that we would want not to deal with. But the general answer is yes.
Can you choose your mediator?
Yes.
Yes.
Yes. This is a categorical yes. The reason is, notwithstanding, there's a criteria for selecting persons to be placed on what is called a roster of court-connected mediators. So we brought with us a copy of that roster, which has, as at today's date, about 40 persons on the roster. Now that list of court-connected mediators is kept in the court and is also kept in the office of the registrar. It's also kept in the office of the mediation coordinator. So the judge or the master, on any day that there is a court hearing, before someone selects a mediator, that person will be given, or those persons will be given, a list of the court-connected mediators. Now I keep using the words court-connected, because there are a number of persons trained who have done the same training as the court-connected mediators, but they are not yet on the court roster of court-connected mediators. They're trained mediators, and they can mediate, but not necessarily at the level of the court, unless they are on the roster. So the roster is given to people who've got a dispute, and they are asked to select who they want to mediate their case. Now, someone may be inclined to select somebody whom they know or someone with whom they have a relationship. The mediators or the trained mediators are always made aware of the possibility of conflict of interest. So not because a mediator is your cousin or your nephew or your brother or your sister that you should select that person to mediate your matter, because it would be left to that mediator to declare his interest or his association with that person or one of the parties with whom he has to mediate. If the two parties agree, well, it's okay, then it can happen. Otherwise, the mediator would have to recuse himself. Now, has that answered your question fully?
In support of what you're saying, certainly, pardon me, in support of what you're saying, certainly when I have done mediation and I have known persons on the day, I have had to declare that I know one very well, or I know both of them, or one is a member of my church, and therefore I need to ask the other party, as Mr. Compton suggested, whether they would wish me to proceed, knowing that I know that person, and it is up to them to determine whether we proceed or not. And it's a good thing.
Just to, off of that answer, caution you, however, in that the mediator is not a judge. So that while we want the mediator to be, as much as possible, to be neutral, and therefore a person probably should try to avoid mediating in a situation where they know people very well and that kind of thing, if it is possible. At the same time, the situation that occurs in a court is not the same as with the mediator. The mediator is trying to assist you to resolve your dispute. The mediator is not going to look at one side and say, you're wrong, and the other one, you're right. And then their personal feelings and their personal connections get involved in the mediation. That's not what a mediator does. So while, everything that has been said by my colleagues is obviously very correct, it is also important to point out that the mediator is not a judge and will not get involved in making those kind of judgments.
Good.
They don't make judgments. They assist the parties. Just before I move on or allow the next question, as a person who is trained in mediation myself and conflict resolution, the question that was asked earlier, I just wanted to add in relation to that the whole question of the celebration, we are coming here because of the celebration of the 50th anniversary of the Eastern Caribbean Supreme Court. But a mediator who is trained can take on any conflict anywhere in the community. As a judge, I am aware that a lot of the conflict in St. Lucia surrounds land, neighbors' disputes, that kind of thing. It does not require a case to be filed in the court for a mediator to be called upon to assist people if they have a dispute with their neighbor. A neighbor dispute is a common thing, and therefore, and it could also be a community issue. One side of the community is involved in doing something that the other side doesn't like. Pig farming. Smells bad. We down here at this end don't like the fact that the fellow up there is doing pig farming. Can we get rid of him? That's a great case for a mediator. So the answer from that point of view is, I want you to understand, it doesn't have to be a matter that has come before the court. It doesn't have to be a matter that a court will want to deal with because it has a lot of technical legal issues and so on. It could be a very simple issue between people who are neighbors being upset with one behavior of the other one next door, loud music, whatever, and they want to see if they can settle it without going to court. And a mediator can certainly assist in those kind of disputes.
We'll move on to the next question now. I'm just going to ask if whoever asked the question, please just state your name and your designation before you ask your question.
Donna Lisa Nelson. I'm employed with the Registry of the High Court. Piggybacking off of what Justice Bell just stated, that a mediator is not a judge or jury for that matter, how uncommon is it for a mediated matter to be referred to the litigation system just because the mediator could not play the role of judge or jury?
If I may. Yeah. Yes. Conducting a mediation session does not necessarily mean that the dispute will be resolved. From time to time, notwithstanding his or her best effort, a mediator may not be able to get the parties to agree on a settlement of their dispute. Now, there are two things. Invariably, a mediation is referred to a mediator after a case has been filed in the court and after what is called a case management program. The master or the judge may decide to send the matter to mediation. The parties will select their mediator and then go to the mediation session. If there is no agreement and no possibility from the trend of things at mediation that the parties will resolve their dispute, that matter then goes back to the court. Now, there are situations, that is, if the matter has already been filed in the court. However, there are situations where lawyers may get together and say, let us try mediation before we litigate. And if we succeed at mediation, then there'll be no reason to file the case. So if the matter is resolved at mediation, then that's the end of it. The lawyers will then take the necessary steps to ensure that the matter is registered legally as having been resolved, if they want to go that route. If, on the other hand, the parties within themselves feel that, look, and with the lawyer feel, look, we will file a matter in the courts, but before we go to the court, or before we agree on a date, a hearing date, we will mediate the matter. If we succeed, we will not proceed. So you have this option. Third, parties with a dispute, and more so after this publicity program, will know that you have at least 40 persons on the court roster of mediators, some of whom you may know. You may decide on your own, agree with them, but there must be mutual agreement with the two parties in dispute. You may decide, rather than go to a lawyer or rather than go to the court, we have a list of names, let us agree on the selection of one mediator. We will approach the mediation office and ask if we can arrange. You can approach the mediator privately, or you can approach the mediator through the mediation office. Did you know that we have a mediation office in the registry? Okay, we do have a mediation office. You can approach the mediation office and say, look, we have a matter, and instead of going to court, or before we contemplate going to court, can you assist us by providing a mediator? And we're prepared to share the cost of the mediator, blah, 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 whatever it is. And you can go to a mediator and save yourself quite a large sum of money, because from what I understand, there is no tariff placed on lawyers for how much they should charge per case. So lawyers are free to charge you whatever they want after they have taken a brief from you. But if you can get together and agree one with the other, you pay $400. If your matter is resolved, that's the end of it. Okay?
In addition to that, if I may.
Yes, yes, indeed.
During the mediation, either parties, there are three individuals that could actually say, look, this is not going anywhere. It appears that we are not going to resolve this. And they want to, say, refer it back to the court. The mediator, the defendant, the plaintiff. can actually do
Yes,
that.
yes.
In addition to this, and I agree with Mr. Compton so very much, that this mediation issue have been in the community for a long time. It was done by elders in our respective communities. Somebody does something wrong, a dispute between a husband and wife, and they would say, why don't we get one of the elders to actually come and talk about it? And once the elder was sitting down with the husband and wife and it's been resolved, as an example, that idea would be resolved. And certainly I have done mediation in my community in Monrepo outside of the court-connected mediation, where persons knew me and came to me and say, oh, Doc, we're having this little problem. What do you think? Can we sit and discuss it? And once the resolution, again emphasizing, once the resolution has been arrived at by the parties, not the mediator, by the parties, everything appears to be all right.
One of the things I really should emphasize is mediation is designed primarily for the benefit of parties to a dispute. It is not really, although in the OECS, the lawyers are the ones who introduce disputing parties to mediation, but mediation is really intended for the parties to have their say, is for the parties to take charge of their dispute with or without a lawyer. In fact, a lawyer does not have to be present during their dispute. The only time is if they feel that they must have it registered in a registry, then they will make the appropriate arrangement. But you can come to mediation without the presence of a lawyer. And we have done, actually, we have had some mediations, and when the parties arrive with their lawyer and the mediator explains the process to them, they realize, well, what do I need a lawyer for? I mean, we can discuss our dispute between us, so the lawyers can go home. You know, that has happened de facto in the past. So a lot of people believe that as long as there is a dispute, there is need for a lawyer. Now, I have to tell you from experience, there are some people, not only in St. Lucia, but throughout the Caribbean, there are some people, if they have a dispute, they must have their day in court, and that's how it's usually referred. I want my day in court. Some people will go as far as saying, this person must be made to pay for his rudeness. And those of you who speak Patois will know, Sefu pay pu had yesu. And that's the attitude and the thing. So they need their day in court. But they don't have to have it since the advent of mediation. You can have your day at mediation.
It's nice.
Question?
Any more questions?
My question, Anne-Marie Joseph, I'm an attorney and also a mediator. My question relates to the standard of mediation,
There?
the standard set for mediation. And how do we ensure that we maintain a standard? You said about court connected and there are other people who practice. What are your views in terms of maintaining a standard of mediation that meets your criteria?
Yes. Now, I have to answer this question in a long-winded way, because we have to start from the beginning with what we call, I should tell you that in the OECS, we decided in the OECS to introduce mediation by way of practice direction. And using that process and that method made it easier and faster for us to introduce mediation in the OECS. Some other territories, like take Trinidad for instance, Trinidad decided to introduce mediation in Trinidad by way of a piece of legislation. However, and that's not casting aspersions on anybody and any process. However, notwithstanding that the OECS have been doing mediation for the last 15 plus years, Trinidad has not yet introduced or yet been able to introduce mediation or court-connected mediation, although they do a lot of mediation within the community. And they've got legislation which answers your question. The legislation sets the standards that are required, and the Trinidad Mediation Act makes provision for a mediation board to check those persons who want to call themselves mediators. The OECS program makes provision for a mediation committee, which is made up of people, various people within the community. Now, we have 3 criteria to satisfy before the court calls someone a court-connected mediator. A is it goes by the way of the criteria for the selection of persons to be trained. So the persons you select to be trained must meet a certain minimum criteria. After the training, the persons who have been trained have to at least undergo a minimum of 40 hours of training as a mediator, more so training offered by the OECS Supreme Court. We have an institution called the Judicial Education Institute, and that institute controls the design of the mediation training. And the third criteria is that that person is likely to be examined by the mediation committee before that person is placed on the roster of court-connected mediators. That is how the process works. Now, in addition to that, and I thought about a question like that, and I brought with me a copy of an appraisal form. Or I call it an appraisal form, but it's an evaluation form. What each mediator is given on the day that's court-connected mediation is given an evaluation form. One form to be completed by the attorney, and another form to be completed by the litigant. Now, usually we have 2 litigants, the complainant and the defendant. Okay? So these forms are expected to be completed by the attorney and by the 2 litigants and handed to the mediator at the end of the mediation program. Now, I have to indicate that we have fallen short because we don't always get that done. However, I have with me, which I got only very late last week, a copy of a very interesting, and this one is entitled St. Lucia 2016. I don't think Justice Bell has seen that yet. Mediation St. Lucia 2016. Now, we've got a statistician in the office who analyzes all these appraisal forms and prepares a report which indicates to the world, to the general public, to all of us, where we going to as far as mediation is concerned. It demonstrates or shows areas of weaknesses, areas of strength, and so on. And that's how we try to ensure the integrity of the mediation program in the OECS. And if we stick to all of this, then there is no reason for us to be concerned. There is another thing which we don't do. The OECS has appointed someone called a regional mediation coordinator, and part of the function of that person is not only to assist in arranging mediation training, but also to assist in dishing out refresher training programs for mediators within the OECS, as well as seeking to maintain the uniform standard of mediation in the OECS. So we've thought about these things, and we actually working on it. We are not always right up to scratch, but at least it is here for us all to see.
Okay, and with that, I'm sorry to say, gentlemen, but we actually have run out of time. But thank you for joining us here today. It's been a very interesting press conference. I also have to thank everybody in our studio audience for coming out and supporting us and having very riveting questions for our panel to actually answer today. Also, I'd like to say thank you for joining us, to our viewing audience, and please stay tuned to the National Television Network. Goodbye.